All right. Oyez, oyez, oyez. The Court of Appeals of the Fourth Appellate Judicial District is now open pursuant to call.
Good morning. Please be seated. Fourth Court will now call matter of the 04-24-204 CR Jose Angel Ruiz versus the state of Texas. I'll invite announcements from counsel, beginning with the appellant. Morning.
Eric Rodriguez for the state.
Good morning. If you haven't been apprised, I imagine you have already. You got 20 minutes each side and a rebuttal. So I will invite counsel to the podium.
Justices, fellow counsel, may it please the court. My name is Michael Goins, and I'm here today representing the appellant, Mr. Jose Ruiz. And I plan to break this argument down into 2 points that were included in the brief. First, justices, I'd like to talk about accomplice testimony. To properly examine whether accomplice testimony has been properly supported throughout the trial, the Texas Court of Criminal Appeals states that first we must eliminate all the evidence of the accomplice. And does any other evidence connect the appellant with the commission of the offense? And mere demonstration of an offense is just not enough. After reviewing the record, justices, there's no other evidence introduced during the trial of this matter that connects the appellant with the commission of the offense. There was evidence introduced that a crime occurred, but once again, that is not enough. There was testimony from several witnesses about hair from the victim's head. That included Nurse Gustavo Cervantes, Officer Ryan Cahill, and Captain Julie Rommel. But at no point did any doctor, nurse, or other witness connect that hair to the alleged victim in this matter. That only established that a crime occurred, not connecting Jose Ruiz to the crime itself. It should also be noted, I believe, that for this to even have occurred, the accomplice would have had to have abandoned her child with Jose Ruiz, who was allegedly an ex-boyfriend. Justices, I believe the issue was properly preserved as accomplice testimony instruction was included in the charge. Moving on to the comments by the trial court.
Before you move on,
Yes, Your
I have
Honor.
a question. Do we need to, I know the standard is we need the other evidence outside the accomplice has to tend to connect him to the offense, right?
Yeah.
So the question I have is, we have many offenses here. We have many counts. So the question is, do we need to tend to connect the Ruiz with bodily injury, or do we need to tend to connect him with each and every count?
I believe you just have to connect him with one account, Your Honor, but I don't believe that was ever done throughout this trial.
I think the question is, do we have to tend to connect the manner and means? Or is it sufficient that we tend to connect that he caused bodily injury?
I think it's enough to connect that he caused bodily injury. I don't think it's through the manner and means, Your Honor, but there has to be some showing that connects him to the bodily injury. And outside of the accomplice testimony, I don't believe anything shows that.
And which count specifically are you referring to that there's no independent corroboration that tends to connect him to bodily injury?
I believe it's on all the counts, Your Honor. There's testimony of the hair.
On all 6 of the bodily injury counts?
Yes, Your Honor. There's testimony as to the hair. There's testimony as to the thumbtacks in the feet. There's testimony as to hearing spanking occurring from next door. There's all sorts of testimony, but nobody ever says Jose Ruiz did this act.
What about his own admissions on a few of those? Pinching.
Yes, Your Honor. There was if you're speaking of the jail telephone calls,
Mhm.
The appellate counsel believes that those jail telephone calls are in direct violation of Crawford v. Washington because there was no chance to cross-examine any of the witnesses on those telephone calls.
That's not before the court though, right? That claim is not before the court. What about his cell phone extraction?
The cell phone extraction did not come from him, Your Honor. It came from the accomplice who gave the telephone over to the police officers.
But it's his phone, correct?
But it doesn't mean they were his messages.
Well, there's videos as well.
Yes, Your
correct?
Honor.
Are you saying your client doesn't own those videos
There
where he's
was,
striking the child?
there was no testimony given during the trial that says that he was the one that made those videos available to the police, or that there was aggravated assault caused to the child during those videos.
Well, that was argued in the court and it didn't go anywhere, right?
Yes, Your Honor,
It
it
was
was.
fully admitted. It's in the record. We can review it.
Yes, Your Honor.
So
And the-
again, what specific counts are you asking this court to disregard because there's no evidence that tends to connect Jose Ruiz to causing bodily injury?
I believe it's all they counts, Your Honor.
All 6 bodily injury.
Yes, Your Honor.
counts.
And you said something, you said that she would have had to have abandoned the child to Ruiz. Didn't he have the child for over 24 hours by himself?
Your Honor, I believe that she testified that he had the child for more than 24 hours by himself.
Okay, that came from the accomplice then.
That came from the
which is
accomplice,
Something
yeah.
we need to disregard.
That's, I believe so, Your Honor.
What about Jordan's testimony?
Jordan.
The 6-year-old, the sister.
Once again, Your Honor, that's from the 6-year-old,
Mhm.
and her testimony was that she was the good girl and that her sister, the victim, was the bad girl. But there was never really any testimony from the child that any of this happened. She just kept saying she was the good girl.
Well, there's a child forensic interview that was introduced by your client at trial that says otherwise.
Yes, Your Honor.
Let me ask you in a different way. What do you understand to be the state's position on these questions, and how would you respond to that?
The state's position will be that there was some evidence that was introduced as to his guilt outside of the accomplice testimony.
And what evidence do you believe they?
I believe the main
Yeah.
evidence they have, Your Honor, would be the video, the audio taped jail calls. But once again, there was an objection to those jail calls at trial. And I believe that they violate Crawford v. Washington, and because they were not allowed to confront the witnesses to those telephone calls. It was raised, the objection was raised and was overruled at trial.
And was that brought forth in your brief to this court?
I believe it was, Your Honor. And the objection was overruled at Reporter's Record, Volume 5, page 221, lines 24 through 25.
Let me ask you specifically about the cell phone. You believe the burden on the state was to prove that, and they proved it through the evidence of a video. Is that right? And that
Right,
was-
I
that
believe that's
was-
correct, Your Honor.
That was admitted through the testimony of an accomplice witness.
Yes, Your Honor.
And you're saying that's not enough to connect or be corroborated?
I don't believe that one video is enough, Your Honor.
And how do you believe the state presented at trial and would hear as well about how they did satisfy their burden in that regard?
I believe the state thinks that they satisfied their burden, one, with the video, some evidence.
What part of the video?
The parts of the video that showed the child being with the appellant, Jose Ruiz.
Now, with respect to the cell phone, I mean, just being in the presence of someone, but how do you believe they support the conviction on the count regarding the cell phone?
I don't believe it supports it on the count regarding the cell phone at all, Your Honor.
Okay, let me rephrase.
Yes.
How do you believe the state and the trial court, because they got, or the jury anyway, what evidence do you believe supports that finding with regard to the cell phone? Not just generally the video, but what in the video reflects that there was evidence that there was bodily injury caused by a cell phone?
Just the injuries that I believe were shown on the trial during the video, Your Honor.
And just the bodily injury is sufficient?
I don't believe it's sufficient, but I believe the state believes it is.
Sure. Okay, so just as a layperson, one might argue, well, what's the evidence about a cell phone? Like, did he have a cell phone? Was it his cell phone? What in the record is reflected for our purposes on review that would support that count?
Your Honor, once again, I don't believe that any of the cell phone video support. that account for the
Forgive
state.
me, from the state's perspective and how you would respond.
Your Honor, I would respond that the video may show injuries, but they do not show the actual assaults.
That it doesn't show the actual self.
I don't believe so, Your Honor.
I'm not sure what you mean by it shows injuries but not assaults.
It shows injuries, I believe, the thumbtacks to the alleged thumbtacks that he put on her feet,
Mhm.
but it does not show him putting the thumbtacks on her feet and making her stand on them.
But it did, I thought Jordan said that. I thought Jordan stated that he had done that to her.
Jordan may have, I don't remember that, Your Honor.
Are you saying that in order for the state to prove that Jose Ruiz caused bodily injury by striking with a cell phone, they're required to prove like the imprint of the Apple, emblem on the child's body, and then you could say, oh yeah, look, cell phone injury.
Your Honor, but they have to have somebody say that he slapped with the cell phone, threw the cell phone, something to say that he actually committed that act. And I don't believe that happened throughout the trial.
How do you respond to the neighbor's testimony?
It was through the walls, Your Honor, and they didn't know who was saying what. They cannot tie Jose Ruiz directly into
But
those.
isn't there a reasonable inference if Ruiz lived there and it was a male's voice and they called him daddy, that it would be Ruiz? Can't the jury pull a reasonable inference from the evidence that was introduced?
I don't believe so, Your Honor. I think they have to show that there's a connection between Jose Ruiz specifically and what the neighbors heard.
So you contend that the neighbors, that the jury cannot draw a reasonable inference that it was Ruiz by the evidence that he owned the apartment, he was identified as the neighbor, there was a male voice involved, and they heard somebody call him daddy.
I guess they could draw that inference. However, there were other males identified that had been in that apartment by the neighbors
But
themselves.
legally, you agree that juries can draw reasonable inferences from the evidence that was introduced?
They can.
Okay.
Well, and in fact, the evidence was that the neighbors heard wailing and a child screaming, stop, dad, stop, right?
That is true, Your Honor. Anything else on point one, Justices?
Not for me.
Justice, moving on to point two would be the trial judge's comments during voir dire. And in accordance with the Texas Court of Criminal Appeals, a trial court commits reversible error. The comments of the court prejudice the appellant's right to a fair trial. Your Honor, this statement happened during voir dire, right at the very beginning of the trial before the jury was even selected. Now, I would contend that Article 38.05 of the Texas Code of Criminal Procedure forbids a judge from making any comment unless it's in response to an objection. Now, there are, I think the major exception to that is voir dire at the very beginning, when the trial judge is laying out her voir dire or his voir dire for the jury panel.
Well, couldn't a court can do its own voir dire if it wants?
Yes, Your Honor, that's what I'm saying. At the very beginning, at least every trial I've been in,
Mhm.
the trial judge at the very beginning of voir dire lays out their questions, what the qualifications are. If everybody's a U.S. citizen, if everybody's a citizen of Bexar County, is anybody over 65 do not want to be here? They always lay out those questions. But once it's turned over to the state to proceed on their voir dire, there shouldn't be any comments from the judge unless there is an objection.
Is there any legal, do you have a case that says that?
Well, Your Honor, Article 38.05 itself says, in a ruling upon the admissibility of evidence, the judge shall not discuss or comment upon the weight of the same or its bearing in the case.
But that's about the admission of evidence.
Sure, Your Honor, I believe it applies even to the voir dire.
Do you have any case that says a judge should not make any comment during voir dire once it's turned over to the
I could not find anything about voir dire comments, Your
And
Honor.
in fact, a judge can actually do the entire voir dire themselves if they wanted.
They could, but once they turn it over to the state and to the defense, they should only be commenting if there is a objection to anything.
But you don't have anything that says that.
I can't find anything. Your Honor, the appellant has an absolute right, I believe, to have at least to try to have an unbiased jury in any jury trial. And that's where the questions from the trial defense attorney came up. Is anybody here worried about having being involved in a criminal trial that involves a child victim. And that's when the trial judge interrupted. The trial judge went into questions of fairness, that the question was actually whether or not they could listen to the evidence and base their decision on what they heard in the courtroom. Well, Your Honors, I believe even that statement is wrong, because the statement should have been a question along these lines should be asked where the jury hears all the evidence and whether or not they can find the evidence, demonstrate that the defendant was guilty or not guilty, and if they were guilty, beyond a reasonable doubt. By not allowing the trial counsel to go into any biases of the jury panel, it just sets the defense up for failure throughout the trial.
So did the judge not allow you to continue questioning of those specific jurors?
It wasn't me, Your Honor.
Did the judge not allow that counsel to continue questioning of those
The
jurors?
judge said the question is actually whether you can be fair or not.
So was the counsel precluded from further questioning those jurors?
She was not stopped,
Okay.
but I believe she was told not to go into it because the judge made a ruling without objection as to what she believed the voir dire panel questioning should be.
So the argument that you've brought to us is saying that the judge said a statement that showed a bias or influenced the voir dire. But what I hear you saying right now is that the error was that the judge cut off questioning the ability of counsel to fully vet the jurors.
Yes,
That's a
Your Honor.
very different argument.
Yes, Your Honor. It should have been, I should have stated as the bias of the jurors. We're not, the defense was not allowed to determine if any of the jurors had any bias in that matter.
If the court were to deem that that was error on behalf of the trial court, how does it affect the judgment that the jury reached?
Well, Your Honor, because it happened so early, the defense counsel was not able to properly vet the voir dire panel. And therefore, there has to be harm throughout the trial because they were not allowed to determine if there were any biases among the jury panel that related to a child victim in a criminal case.
Again, that's a very different argument that you've presented in your brief. Don't you agree?
I do, Your Honor.
Okay.
Pending any questions, Your Honors, that's all I have.
You'll have us all the time. Thank you, counsel.
Good morning, Your Honors, opposing counsel, and may it please the court. My name is Eric Rodriguez. I'm here on behalf of the Bexar County District Attorney's Office. So the points of error Mr. Ruiz raises on appeal are simply not supported by the record. The record does indeed show that Mr. Ruiz was properly convicted for his pattern of horrific abuse. So when we're talking about corroboration, I think opposing counsel is starting from a misunderstanding of the way Article 38.14 is supposed to work. When I was preparing for this oral argument, I ended up finding a case from 1921 called Boone, and the citation for that is 235 Southwest 580. And what I'm hearing from opposing counsel is that—
Not even a second.
Not even a second, Your Honor.
I hope you were up till 4:30 in the morning.
But I think the crux of his argument is that there's no evidence in the record that tends to connect him to the offense. And the way that he's viewing that is there needs to be something affirmatively showing him committing an offense. But when you read the Boone case, you'll see, and this is like a bank robbery back in the 20s. And what the Court of Criminal Appeals at that time realized was, well, when we're talking about accomplice witnesses, what are the situations where we use an accomplice witness? And it would be like a robbery. It would be like a murder where there's not a lot of people around. We need somebody to say, this is the person that did it. And what the Court of Criminal Appeals realizes is that if there's other evidence that says this is the person that did it, you don't need that accomplice witness in the first place. So
How does that fit in with the legislative enactments that occurred since 1920 regarding this article?
well, Your Honor, it is an older form of the statute, but it is very similar. It was under the Code of Criminal Procedure at that time, but I think the principles behind the issue are still the same. We're looking for evidence that,
That you need to corroborate your accomplice witness
Ye-
testimony, right?
yes, Your Honor. And so,
Because we'd all get just our sisters and siblings to like say something different, like, you know what I mean? Anyway, I'm just giving you a hard time because there's interns in the room and I just want to give you a hard time. No, the matter before us obviously hinges on our interpretation of how to apply the accomplice witness rule on review. So from the line of questioning we've given to appellant's counsel, what might you perceive to be some of the challenges raised by the appellant on some of the evidence presented by the state to corroborate accomplice witness testimony? Let me start with the cell phone. Tell me how the state proved that.
so with the cell phone, Detective Knox testified that the phone number was his, the phone was registered to him.
I'm sorry, that's not the question. It's the striking with the cell phone.
Yeah. I'm gonna let you answer, but just, yeah, I think you know what I'm talking about. What
Okay.
evidence showed to prove that count?
I apologize, I misunderstood the question, Your Honor. I think the corroboration here, and the case I cited in my brief, Cox, talks about what are the things that corroborate presence, opportunity, admissions, physical evidence, things like that. So when we're talking about the striking with a cell phone, I think the evidence in the record that supports that is simply the bruising on the child's body. We're not talking about needing to prove beyond a reasonable doubt. The standard is tends to connect and not tends to prove beyond a reasonable
Was there
doubt.
any evidence giving him that he was in a position with an opportunity to do that?
Yes, Your Honor. And specifically, the photos that were found from his phone, the metadata on those pictures shows that Mercedes was in his custody between the dates of January 21st and February 5th. And February 5th is 2 days before Mercedes died.
How are you asking the jury to make that leap, though, that just based on the amazing number of bruises on that child's body, that one of those bruises somehow was caused by the striking of a cell phone? So we want the evidence that tends to connect the striking with a cell phone. Because what if you had 100 counts on your indictment? How is the defendant supposed to prepare for trial if you say manner and means is striking with cell phone, but then at the end, you're like, well, it's, just look at her body. We proved it. Is that enough?
I think that's more of a question of sufficiency of the evidence as opposed to sufficiency of the accomplice's testimony, Your Honor. So
But you need
Why-
to tend to
If I
connect
may,
him.
I really want you to get back to my question if you could. Again, you were telling me what evidence and you started about the metadata. What else? About what evidence corroborates the accomplice witness testimony regarding the cell phone? Just if you could focus on just that, please.
And the state would, in that situation, would rely on that he was present with her, that there was evidence that there was striking going on. And so that tends to connect with the offense. And then I would agree with Your Honors that it doesn't get us to beyond a reasonable doubt. But then that's where Ms. Mendoza's testimony comes
I understand it
in.
doesn't heed to you. I understand that corroborating evidence, it's a pretty low hurdle the state has.
Yes, Your Honor.
About it, but it could a rational juror make this finding, right? And even if two jurors or two rational people could disagree, we have to defer to the fact finder here. I'm just asking you to delineate what evidence the state relied on to prove that count relating to the cell phone. And you mentioned the photos that were found in the cell phone that I guess tended to connect the accused with the injury to the child by cell phone, at least as charged, right?
Yes.
And you said, and you talked about the metadata. I'm familiar with that. Counsel mentioned something about the video. Was that something the state relied on as well? What other, I'll just open any question. What other evidence in the record supports that count to support the corroboration of the accomplice witness?
I think for this specific count, I will agree that the evidence was weaker than the other counts. But I do think that because we have such a low standard for corroboration, that the jury could reasonably infer that one of those injuries was caused by a cell phone. When you're adding in the testimony that from Katrina that this is something that Mr. Ruiz would do.
What if the case law would not support, what if the state's precedent wouldn't support, a charge of, you struck somebody from a cell phone just because there's pictures in the cell phone about, on BI? What other evidence is there? Because that would be the case that anybody in a BI case who had pictures in a cell phone would support this kind of separate count. So to the extent that it would need more, what would you point to?
Your Honor, I think the state would just have to rely on the presence, opportunity, and injuries on the child. I fully agree with the court that the evidence on this count was one of the weaker counts. I think I even addressed that in my brief. But I do want to point out that, and I do address this in my brief as well, that error was actually waived as to the count that gave Mr. Ruiz the highest sentence, and that was the life sentence. In his briefing, opposing counsel failed to address the actual count of conviction. So if you compare if you look at the indictment in Court's Record 10, the portion that says pulling a sock out, that manner and means was actually stricken. And
Well, I'm glad you brought that up. Why did the state charge unknown manner and means if you clearly knew the cause of death?
I have to defer to the trial prosecutors. I did not indict this case, Your Honor.
But you brought it up as in, and I understand what you're saying.
Mhm.
The language of the sock, pulling the sock out of the mouth, I understand was waived right before trial.
Yes, Your Honor.
That error is waived. There was no objection. State moved, defense didn't object. We got it. And so what's left in count one is paragraph A only, was the unknown manner and means, right?
Correct.
But you don't dispute you knew the exact cause of death and that both Dr. Molina and Dr. Kanan agreed.
I don't dispute that they testified to what the cause was. I just don't want to speak for what the intake prosecutors knew at the time.
So do you agree with, I'm assuming you agree with the appellant that the standard is whether we can tend to connect him with bodily injury, not each and every manner and means?
Yes.
Okay. Can you go back to, you mentioned it very quickly. Can you go back to the legal case law that you found on tends to connect and what that standard is?
Yes. So we're simply looking for, and I believe Reed is the case I cite in my brief. The question is, could a rational juror connect the defendant to the crime without the accomplice testimony? And in the record, there is substantial support for that.
But what does tends to connect mean? That's what I'm asking, that language.
Tends to connect, I think, goes into that. I think Reed answers that, is that it tends to connect means that the jurors making the inferences from the available evidence and the direct evidence, does it allow the jury to make that logical inference that
Right,
he's the one
I'm
who did it?
asking you, how does the case law instruct us on whether something tends to connect? What kind of things should we be looking at to see if it tends to connect the defendant with the injury?
And
You
then,
mentioned motive, opportunity, that kind of
Yes.
stuff.
so in that case, I would rely on the Cox case that was cited in my brief, the president's opportunity, admissions, physical evidence, and all of those factors are present here in this case.
Presence, opportunity, physical evidence.
And admissions of the defendant, Your Honor. And specifically in this case, you see in State's Exhibit 6A, from the get-go, Mr. Ruiz is very evasive, does not want to be involved. In State's Exhibit 111, the jail call, he says, if that autopsy comes back and I'm in jail, I'm staying in jail. And State's Exhibit 108, the video of him driving Mercedes to his apartment, where he says, didn't I tell you it's not going to be fun at my house? And he's actually seen on video striking her. and she can actually be seen holding the water bottle up in a manner which could reasonably lead to the development of rhabdomyolysis if that exertion is prolonged.
Can you point us in the record where the tends to connect evidence exists for the allegation that he covered her nose and mouth?
So in my brief, I state that that was another one of the allegations that there wasn't a lot of evidence, but there was some. And I believe it was Dr. Cannon in the record who testifies that in her file, there was evidence that there were episodes where her mouth and nose were covered. Now, I do admit that that was hearsay, but it was not objected to, and it therefore comes into evidence.
Well, unlike the cell phone count, in this count, the defendant actually talks about times when Mercedes would cover her own mouth and made herself pass out. But you don't have that with the cell phone count, do you? There's nothing other than Katrina's testimony on the cell phone.
Nothing other than Katrina's testimony, the presence of the defendant, and the bodily injuries that could have resulted from that. And again, I do agree that that is probably one of the weaker counts in the indictment. I do want to talk real quick, if there's no other questions about that point, about the improper comment during voir dire. In my briefing, and I submitted a supplemental brief about this issue, I argued preservation that was in direct contravention to Prenza, which is cited in my supplemental brief. But I do want to talk real quick about 38.05. And there's a case called Zhang Yong Kim versus State. The citation is 331 Southwest 3rd, 156. And it's talking about what reasonable calculation means. It's out of Houston, but it's pet refused. The way the Court of Appeals in that case read reasonable calculation was that reasonable calculation means that the jury understands the court meant their comment to endorse the state or undercut the defense. And at this point, both in the briefing and in the argument, I still don't think there's an articulation of how that comment was improper. In my life before I became an appellate prosecutor, I was a trial prosecutor, and it was very common for judges to interrupt voir dire when there was a sticking point and the judge thought that they could kind of help move things along. And I think that's exactly what happened here. But even in the case where there is error found, I think if you look at the record, and specifically pages 299 and 152, you'll see that every juror that raised their card in response to the judge's question was an agreed strike at the time the parties agreed to strike jurors. So if anything, I think Mr. Ruiz's panel got better as a result of the judge's comment because there was absolutely no argument about those specific jurors.
So they weren't struck for cause, they were.
They were agreed strikes.
Okay.
And with that, Your Honors, if there are no further questions, I would waive the rest of my time.
I do have a question. If the court finds that the trial court's comments were error, how does it affect the judgment?
It doesn't because it's harmless. That was the point of my argument that the panel got better for Mr. Ruiz after the judge's comments, because I don't think there's a way to read that to find that it affected his substantial rights. If there were jurors that raised their hand and defense wanted to argue about those specific jurors at the time, then maybe there could be some kind of prejudice to his substantial rights inferred. But here I find it very difficult to read the record in a way that would cause any sort of prejudice to his rights, let alone the type of prejudice that would rise to a reversible error.
Well, I think you'd agree that if in fact the trial court had cut off questioning of jurors for bias, but those jurors didn't end up on the jury anyway, that's harmless error, correct?
Correct. All right, with that, if there are no further questions, I waive the rest of my time, Your Honors. Thank you.
Briefly, Justices. I would like to respond to the bruising question that was raised to the state of Texas. There may have been bruising with the phone, but there is no evidence of who caused the bruising. And there is no evidence of which phone was actually used to cause that bruising, whether it was the appellant's or not. And as far as the metadata, that shows that the appellant's phone was present, but it doesn't show that the appellant himself was present in that apartment at the time. As I think you can see from the back and forth throughout the trial, that both parties had that phone at any specific time. I believe even when the child was taken to the hospital, the accomplice had the phone and not the appellant at the time. As far as the neighbors, they may have heard screaming, but there was no evidence as to who was screaming. Which child was it? And there's also no evidence as to which male it was, because they never said it was the appellant who they recognized his voice. The state made a comment about the jail calls. I believe it was, I'm in jail, and if the autopsy comes back, I'm staying in jail. That's not an admission of guilt. That's just the fact that he knows that when the autopsy comes back, it's going to show the baby died for some reason, and that they're not going to let him out of jail because he may be the one connected to the case. I don't believe they show he was connected, but he may have been the one while he was in jail. And I believe, as the justice stated before, there's no evidence of who covered the mouth. There may have been testimony that the mouth had been covered and the nose had been covered, but there was no evidence of who did it.
So if we agree with you on all of that, the individual injuries, the cell phone, the covering of the mouth, pulling of the hair, but we still have evidence that he pinched her to the point of bruising, that he struck her, the things that he admits he did. Is that not sufficient to show that that tends to connect him to the bodily injury of the child that died?
Not to the aggravated assault of the child, Judge.
Explain that to me.
I don't believe there can be a connection from the pinching or any things you just mentioned that shows that the baby died because of those actions.
So we have to find that she was struck by a cell phone and that he covered her mouth?
Your Honor, I think it has to connect to the death of the child or to the aggravated assault.
Right, and I think the medical examiners were really clear that they know it was rhabdo that killed her, but it was a history of trauma over several days that would have caused that breakdown of muscle, right?
Yes, Your Honor, that's what they said.
And so if we have him admitting and some other evidence showing that on various days he pinched her to the point of bruising, he struck her, all the things that he said he did, pictures of her holding up things for a long time, that's not enough? It's not, you're saying that's not aggravated?
I don't believe it's enough for the aggravation, Your Honor. And as far as the jury argument, I don't believe the record shows that the question was asked about any bias towards a child victim, and people raise their cards. But fewer people raised their cards when the judge reframed the question as to fairness. And I believe that the appellant was not allowed to flush out any bias within the jurors because of the judge's comment.
But did they ask to do further questioning?
I don't believe so, Your Honor.
Would you agree that because those jurors are not on the panel, then that error is gone?
I don't.
Let me rephrase this, if I may. But what do you understand to be our standard review on improper judicial comment?
I believe, Your Honor, should be de novo because it's not a waivable right to have an unbiased jury.
That said, then what would be, again, our review in terms of on this record where we could determine there was in fact some harm related to that comment regarding fairness by the court? So assuming without deciding, what evidence of harm to the verdict, basically?
Your Honor, I don't know how you would tie the jury argument to the verdict and show a specific instance of harm. I don't think that can be done. The harm goes as to the appellant having the absolute right to have to at least try to have an unbiased jury panel in his trial of this case, Your Honor.
Yeah, and I don't disagree that, if your position is that if a juror ends who makes, yeah, I won't go there. Very good. You have a few more minutes.
That's all I have, Your Honor, is pending any further questions.
Very good. Your case is submitted and an opinion is forthcoming. So this case is adjourned. Have a good day. Peter's high, which is why I have to.